Hello everybody, my name is Paul Godfrey. I'm an attorney from Florida. This video is not investment advice or legal advice. It is for educational purposes, but hopefully you also find it entertaining. Please like and subscribe. I hear people say that, so I figure I should too. I'm going to start with some preliminary matters. First thing I'm going to say is I do own digital assets. I bring that up because that has two implications. The first implication is that you can use that when trying to judge my credibility as to whether or not you think I'm being fair. One of the things that a lot of journalists will do, or people say that journalists should do, is say, if they ever write about a stock or something, it's usually prudent for them to disclose, well, I own this stock, so that way, the reader can take that as a factor into considering the credibility of the article. So in that sense here, you're listening. I do own digital assets. However, I don't believe that's going to affect or skew my judgment at all, but it would be unfair for me not to tell you that. The other reason I tell you that is because I do want them to succeed. I do believe they will succeed. I do believe adoption is on the way, but that's enough about that. The second thing I want to bring up is that I make mistakes. I'm not perfect. If I ever do that, please, by all means, feel free to correct me. My goal is, again, accuracy and credibility. And a few of the things I want to point out, I'm actually going to do this from now on. If I ever notice that I make a mistake when watching my videos, I'm going to try to bring it up at the forefront of the new videos, so I can be like, oh, I misspoke here slightly. So for instance, a few of the big ones was I was calling it the Kleinman v. Wright case. There is no first in before the M. It's not Kleinman, it's Kleiman. So my apologies for mispronouncing that the whole time. At one point I also said the amount of damages in question but split between two parties was $500 million. It is actually half of $10 billion, so that would be $5 billion, not $500 million. And then also I think in my first video I misspoke and said Codius instead of coil, or coil instead of Codius. Again, I'm not perfect. I might misspeak every once in a while, might get it wrong. But I'm going to try to put this up front as opposed to like a newspaper that would put a 5th page correction. I also started looking at analytics on my video. I saw my average view times. I noticed my videos were like 20 minutes long, 30 minutes long, 40 minutes long. And when I first started, the average view length was like 2 minutes and 30 seconds. So it's like, okay, well, I got to do something about that. Let's rethink this format. So I've actually put a stopwatch up. I'm timing myself. You can see it right there in the bottom left corner. So that way, I started this one a little late, but I'm going to try to keep it to about 10 minutes, and that way things don't take too long and I don't lose your interest. Last thing is, generally speaking, I'm gonna try to point out both sides in each of my videos. Usually there'll be a theme for each of my videos, or at least I'll try to make it so you can be like, oh, okay, that makes sense, as opposed to just talking about things sporadically. So one of the things that happens, especially in the legal world, is you get 3 types of briefs. You'll get the plaintiff brief or petitioner brief, you'll get the defendant or defense brief, and then you also have law clerks and judicial clerks who work for judges, and they'll give what's called a judicial brief. Plaintiff briefs are obviously in favor of the plaintiff, defense are in favor of the defense. Judicial briefs try to present both sides, ultimately so that the judge can make the right decision. So I'm going to try to go ahead and present both sides. I'm not going to give strategy, what I think, for either side, because I don't think that's my place. I'm just going to try to analyze it and let you all make your decisions on that. But anyway, about 3-4 minutes in, let's move on to the case. So today we are focusing on the parties to the case. The Ripple Party. That's what I'm naming this video, the Ripple Party. Done. So the first thing is, went to the docket here. Actually, let's see. Nope, those are the... Hold on a second, YouTube. Pull up the next document. Ripple suit. I want you to be able to see the docket. So I didn't have this one open yet. Basically, once a week, I'm printing out this docket. Every single time you view it on Pacer, it costs money. So this is the 9/9 docket. I printed it earlier today. You can see that they still have to respond. There's been no response yet to the amended complaint, which ultimately we'll see most likely some sort of motion practice after that, but we're getting ahead of ourselves. What I looked up today was a notice of removal, and so that way we can focus on the parties. If you look at the notice of removal, it's not just one Ripple lawsuit. It is now, and it's in federal court, but initially there were 3 separate lawsuits filed in state court, and this notice of removal is a very good summary of it. So we're going to go over the first 3 paragraphs, and you can see I've got some of it on the right. Being from Florida, I had no idea how to search the California dockets. So that was part of my learning experience, and I'm going to take you through what I learned, and that way, in case you want to look up some of these things, you can absolutely do that too. You can make your own conclusions. So you've got paragraphs 2, 3, and 4. They talk about the 3 state cases. This is in the federal case, the notice of removal, but the second paragraph discusses the first case, the third paragraph discusses the second case, and the fourth paragraph discusses the third case. So what I did is I went ahead, I took this case number, I went to the online California case access in California. As I found out, you have to look up the specific court docket. There's not just one. I didn't mean to do that. It doesn't matter. There's not just one database, and I shouldn't have been surprised by that because it's the same way in Florida. If you want to look up any specific docket or documents, it's done by county court to county court. So I don't know why I was surprised about that. Doesn't really matter anyway. But you'll get to see what I did. So I went up and I looked up all these cases. So this was the first case. It was filed by a gentleman named Vladi Zakhanov, and it was filed June 5th, 2018. I saved a copy of the complaint. I'm going to read through that later. Probably not going to share it with you because we have the amended case in federal court. I'll get to that in a bit. But shoot, 3 minutes left. Let's be quick about this. So I looked up each of the cases. There's the Zakhanov case. There is which one is this? This is the O'Connor case right here, and it was filed, the second case filed in June 27th, and then I went ahead and I looked up the third case, which is the Greenwald case. That gentleman or lady is a resident of Israel, so it's international. It goes with the class action. That's something for a later date, but that complaint was filed June 3rd. So we have 3 different cases, 3 different complaints. So what do you do? What happened was the cases were consolidated, meaning out of 3 cases, the judges basically said, no, you all are basically talking about the same thing, the sale of XRP, Ripple Labs, and who are the specific defendants? You can see them right here. Ripple Labs, XRP2 LLC, and then all these individual people. So basically, because they all dealt with the same matter, the sale of XRP, the judges were like, boom, no, not 3 cases. We're going to decide this in 1 case. Then, once the cases were all consolidated in state court to 1 case, what the attorneys for the defendants did was remove those cases to federal court. And that's why you may have seen me looking at the federal dockets. It's a nice place where everything is happening. So in case you don't know, in the United States, we've got separation of powers. That's more so between the 3 branches of government, but you also have a unifying federal government that has supremacy over the various state governments, but the state governments allow for local representation. We think it's good not to have, somebody in Washington, D.C. control everything we say. The people of California get to determine what the people of California do. The people of Florida don't get to tell the people of California what to do. The people of Utah don't get to tell the people of what Alaska do. That's why we have state governments. So anyway, the states have their own courts. The federal governments have their own courts. Both of them, all have the 3 branches of government: judicial, legislative, and executive. So these are the judicial branches. And in short, there were 3 state cases. They were consolidated into 1 state case, and then that 1 state case was removed. That's the term of art, to federal court on motion by the defendant's counsel. So removal is when a case moves from state court to federal court, and that's where the action is currently pending. So why am I going over this? Well, the parties. You had these 3 state cases, and the parties for those 3 state cases were Zakhanov, Greenwald, and O'Connor. Is that it? Zakhanov, O'Connor, and Greenwald. There we go. So why am I bringing all of this up? This is my first point. There's the alarm. Try to keep it quick. We'll wrap it up right now. You may have heard people talking about the Howey test, etc., but I looked up the Howey test. Here's actually, I'm going to show you something real quick for anybody who's interested. This is just something I like. There's a website, scholar.google.com. You can go ahead and look up case law. Anybody can do this. It's free. Federal courts, and then I just typed in Howey test. You can see that. Click on Howey test. It pulls up a bunch of cases. It uses, it's not as advanced as something like Lexis or Westlaw, but you can do basic Boolean searches, and it works pretty well. It's not as current and up to date as those. But anyway, why am I bringing this up? We bring up the case. You see it. Who are the parties in this case? It's this SEC, Security and Exchange Commission versus W.J. Howey. So the SEC v. Howey. Why is that important? Well, this is a federal administrative agency against Howey, an individual. Well, a group of people at all. Why are we doing that? Why are we looking at that? Well, when we compare that to the parties in our consolidated federal case, you can see that there is no SEC here. This is not the SEC versus Ripple Labs and XRP, 2 LLC, and the various other defendants. These are private individuals. That is, again, Zakhanov, O'Connor, and Greenwald. So the people who are big fans of XRP, I don't know if I'll call them XRP Maximus, but in short, they're going to be like, well, it's not the SEC against them, so not a security. Well, not necessarily. The point is this court, United States District Court for the Northern District of California, has jurisdiction over them, over the parties, and it could very well determine through this court case that the manner in which XRP was being sold is a security. I'm not saying it is, I'm not saying it isn't, but I just thought it was interesting and thought you should notice. Again, this is not the SEC coming down on Ripple and XRP. That is Ripple Labs Inc. and XRP2, as opposed to XRP, the digital asset, which we all know, ZERPs, as some people might call them, OpenCoin, whatever. But does that mean that potentially these people are out of the clear? No, it does not. The court can still absolutely rule that this is security. So that's it for now. I've already ran over my time. This is probably 15 minutes, something like that. Be well and be kind to each other, and have a good night.